Okay, welcome to our educational presentation, Emergency Detention, EM1JustTheFacts. I'd like to introduce our speaker, Dan Kepke, who is Team Facilitator of Case Management at Bellin Psychiatric Center. For those of you who are interested in nursing contact hours, please make sure you have signed in on the roster, taken the evaluation form, and at the end of the presentation, when you turn in your evaluation form, you'll receive your certificate. Okay.
So, I'm Diane. Let me just tell you a little bit about what I do. I am the team facilitator of case management here. I've been doing this for about 25 years. I'm very familiar with the EM1 process. In addition to doing that, I'm also on the countywide EM1 board and have been on that for about between 15 and 18 years. So that's where we go and talk about the changes in the laws, any changes in the practice for Brown County and what we're going to do there. So this is the slide Karen tells me I have to have in here. It tells that I have no conflict of interest, and the only reason I do this is because I want people to have the knowledge. So what we want to be able to get out of this today is for you to understand exactly what an EM1 is, what it takes to have an EM1, what the criteria are, and to talk a little bit about what the difference is between a settlement agreement and commitment. So, Chapter 51, what is it? Chapter 51 is the legal statute that controls when we're able to hold people for the purpose of mental health treatment. It is a federal law, and it's what we are all required to follow, and it's part of the Mental Health Act. The subsection that covers emergency detention is 5115, and this is when you can actually hold a person against their will. So when we're talking about EM1s around here, sometimes we call them a Chapter 51, but that's what we really mean, is we're operating under Chapter 5115 in order to hold a person against their will so that they can get mental health treatment. Now, in order to hold someone against their will, for the purpose of this, there are 3 criteria that have to be met. And those are that the person is a danger to themselves or to other people, that the person has a mental illness, or we suspect the person has a mental illness, and that the person is a suitable candidate for treatment. So just because a person is dangerous to themselves or others doesn't really mean that they meet criteria for Chapter 51. There has to be the other 2 criteria as well. So the process of emergency detention works like this. The first thing that has to happen is that the police have to be involved, and they're the ones who determine the dangerousness, and they're the ones who determine that, yeah, they think this person probably has a mental illness. Now, are they diagnosing a mental illness? No. They're just saying we suspect there's something going on here more than just an angry individual, and we're going to detain them for that purpose. The other part, then this is a little bit newer part of the law, is that every county has an agency that's appointed to approve EM1s. So there has to be a policeman who says, yes, I believe this person needs to be detained. And there also has to be a county agency who says, yep, I think the policeman is right, this person does need to be detained for this reason. Those are the 2 criteria that need to be met. Now, the only people who can decide those 2 criteria are the other people. So even if we have a person that we believe needs to be under a mental health hold, we can't really encourage them to do that. We can ask them to do that, but it still has to be made, the decision has to be made by the police and by the county agency. The other thing you hear is that this is a 72-hour hold, and what does that mean? 72 hours are business hours, and I'm not sure that this is real clear to patients when they come in, but that means Monday through Friday, business hours. It does not mean weekends, it does not mean holidays. So if a person comes in on, Wednesday before Thanksgiving, their 72 hours are going to be up until the following Tuesday, because we don't count those legal holidays and weekends. This is a state allotted time. There's been a lot of controversy lately about when a 72 hours starts. And this is something that I'm going to tell you about the controversy, but I'm also going to tell you this is not up to us to decide. The law says that the detention starts when a person is detained for the purpose of an emergency detention. Now, some of the law enforcement agencies say, okay, so if I pick someone up for the purpose of an emergency detention, that's when the 72 hours starts. But there's that second piece of the puzzle, which says that the county agency has to okay that, yes, it is appropriate for an EM1. So some of the agencies are saying, so really it doesn't start until the county agency says, yes, it is a suitable EM1. And then that's when the 72 hours starts. What I can tell you about this is that's not a battle we should fight. That's not a battle anybody in this room is going to fight. Whatever time they put on the emergency detention form is the time we're going to go off of. I don't care if the police put the time on. I don't care if the social service agency put the time on. It's their job to determine that, not ours. If the courts want to fight that, that's their job to fight it. Like I said, I go to the county EM1 meeting in Brown County. This is a huge issue. We have police forces who say, when I detain them, that's when the time starts. We have our corporation counsel, who is for all intents and purposes the prosecutor in our county, saying, no, it's not until the crisis center, in our case, okays it. So if they want to fight that out in court, that's up to them. If they come in with paperwork, the only thing we have to do is say, is it filled out? If it's totally filled out, you say, thank you, take it, and let the court fight the rest of it. So the 72 hours is so that a psychiatrist can evaluate the patient. And what we want of the psychiatrist is to evaluate to make sure that they're meeting the 3 criteria. Again, are they a danger to themselves? Do they have a mental illness? And are they a suitable candidate for treatment? A danger, that's kind of a subjective thing, because we get a lot of people who come in here and say, I didn't really mean it, or that was an accident. So that's a judgment call on the psychiatrist. The mental illness, again, that's based on the psychiatrist's years of experience in that case. Are they a suitable candidate for treatment? What that means is, if you have someone who is severely developmentally disabled, they probably aren't a suitable candidate for treatment. If you have an elderly person who has Alzheimer's disease, they are probably not a suitable candidate for treatment. Those kind of patients are not going to meet criteria to be held under a mental health commitment. Are there other ways to hold them? Probably. But for the purpose of an EM1, that does not meet the criteria. So what happens if the doctor comes in and the answer is no, they don't meet these criteria? Well, that means that the emergency detention gets dropped. In the case of a person being in the hospital here, if that is dropped, the patient still has a chance to agree to be voluntarily treated, but they don't have to. If they don't want to be treated, they can go home. There's nothing we can do about that. Any questions so far? So what happens if the answer is yes? Well, there are 3 options then. When the answer is yes, they meet those 3 criteria. The doctor can still decide to drop the emergency detention. He can say, yeah, they meet all the criteria, but they're agreeing to get treatment, or the dangerousness is passed, or whatever it is, I feel that they're safe to be either treated voluntarily or to go home, and we can drop that action. The second is that we can send them to court for a 90-day settlement agreement, and I'll talk more about that. And the third is that we can pursue a full commitment. So what's a 90-day? A 90-day settlement is exactly what it sounds like. We're going to settle this whole matter by saying for the next 90 days, the patient's agreeable to do the list that the doctor puts together. And it's a pretty standard list for most patients. It's things like not take illegal drugs, not use alcohol, keep all your doctor's appointments, take all your meds, yeah. No hurting yourself. Marnie's helping me here.
Or others.
Or others, correct. So this goes before the court, and the judge basically looks at this and says, you know, your doctor thinks you'll be okay if you can agree to do these things for the next 90 days, says to the patient, do you think you can agree to that? The patients say, yes, of course we can. And so what happens is, then that court action of putting them under a whole commitment is basically put on hold for 90 days. And if nothing happens in that 90 days and the person does exactly what they're supposed to do, the action is dropped, it never goes on their permanent record, and things just move on from there.
Who's monitoring that?
Diana's asking who monitors that. It's a very loose monitoring, but it's monitored by a social worker from the county. My experience with that has been that usually as long as things are going along fine, there isn't a whole lot of contact with the county. However, and we see it with family members, if a person's starting to use drugs or alcohol or not taking their medicines, then you have a person who is assigned to that case, and you can contact that person, and then they can decide if they want to take further action. So, and this is more of the same. What does it mean for the patient? It means exactly that they're going to stay safe, they're not going to use drugs or alcohol, they're going to take their meds, they're going to go to their appointments, and they will have a county social worker assigned for oversight. So the commitment, what is that? A commitment is much more restrictive than a 90-day settlement agreement. This, they can take a person to court for a commitment even if they're not agreeable. The 90-day settlement is an agreement. The patient has to be agreeable to that. A commitment, the patient does not need to agree. The doctor is the one who testifies in the initial hearing here, so they will take a person and the person can say whatever they want, but the court's going to ask the doctor's opinion. You've had 72 hours, what do you think? Does this person meet all three criteria? If the answer is yes, then they pursue a commitment. So the first step in the pursuing of a commitment is the probable cause hearing. And like I said, that's where the doctor testifies and says, yep, I've evaluated them. They do meet criteria to be held under a commitment. They meet those big three. The judge, if he agrees that the doctor has proven this, then will say, okay, we're going to take this to a final hearing. And then they appoint 2 independent doctors to come and also evaluate this person. So it's not just based on the testimony of one doctor. A commitment has to be, I mean, the person can agree to a full commitment, but for the most part, they appoint the 2 independent doctors, and then it's the opinion of the 3 doctors combined that can lead to the commitment. Now the judge can determine at that initial hearing that there isn't enough criteria and that there isn't probable cause to say that this person is going to be dangerous and has a mental illness and is a suitable candidate for treatment. If that happens, the court action is dropped and the patient's free to go.
Does that happen?
Yes.
Yes, Diana asked, does that happen? Yes, it does. Sure.
Diane?
And they can leave that hearing with a med order too.
Yeah, the probable cause hearing is a hearing, so they can, if the initial doctor testifying says, you know, this person really needs to take their medicines, they can add a medication order on as part of that probable cause hearing.
But so the judge is overruling the medical profession.
Yes, the judge, can the judge overrule the doctor? Absolutely. The judge has the final say. That's what makes him the judge. And it's usually not about arguing with the doctor about whether they meet the criteria or not. It's more, I think, a matter of was everything done correctly? You know, did the patients, were their initial actions dangerous? You know, or is it just that someone heard they were going to do a dangerous thing? There's all kinds of different reasons why a judge would drop it at a probable cause hearing. It's not just that he's disagreeing with the doctor. But, you know, the doctors are there because they want their patients to get treated. So they're going to present the case to say why I think my patient needs to be treated. So before the final hearing, we have these 2 independent doctors that are going to come and see the patients. And they are doing exactly what the first doctor did. They're going to come in, they're going to do a full evaluation of the patient and say, is this person meeting all those 3 criteria? Are they dangerous? Are they a suitable candidate for treatment? And what's the third?
Their mental illness.
And do they have mental illness? That's right. Thanks.
So can you tell us a little bit about what the independent doctors, like what criteria do they need? Like counties have certain ones, do they not be partners? How does that work?
So Karen's asking how we get the independent doctors and what their role is. The independent doctors are assigned by the county. They do not have any relation to the hospital. The reason they're independent is exactly that. They don't want someone who's connected with the hospital or connected with the doctor that's just going to go along and agree with what they say. They want someone who's going to give an honest, unbiased opinion. So they never have, you know, we would never have 2 of our doctors evaluating the same patient. The doctors come from outside of here. They can be psychologists or psychiatrists. So it's not necessarily all just psychiatrists.
And then when they come as far as access to the health record, you don't need any consents or violations?
No. This is a court-ordered evaluation, so if we have a person here held under a court order and and independent doctors are assigned by the court, they have full access to everything in our records. They have full access to talk to the staff. You know, I'm sure they can talk to the family and do all that. So they don't need any permission from anybody except the judge to be able to come here and to access all of our records. So then we go to a final hearing. And, you know, and I should have said at the probable cause hearing, it's not necessarily only the doctor that testifies. There's also witnesses listed under the emergency detention on the EM1 form. And at that time, those people can be called upon to testify as well. Usually it's family members or crisis people who have witnessed these people acting dangerously. And they can't testify to mental illness, but they can testify to dangerousness. At the final hearing, they usually have the 2 independent doctors testify. And that's when, you know, we see how much they agree with our doctors, and that's also when they determine if it's going to be a 6-month commitment. They can, you know, they can do all kinds of funky things at that last hearing. I've seen them go and drop it at the last hearing. I've seen them go and change it back to a settlement agreement, or they can court order the 6-month commitment. And again, it's based on the testimony of the 2 independent doctors. So what does it mean to be under a commitment? Usually commitments are 6 months or a year, depending on the patient and the situation. But what it means is that you are under county supervision for that length of time. You can be put into a hospital, you can be put into a residential setting, you can be sent home. Commitment doesn't mean you have to be institutionalized. It just means that you're going to be supervised by the county for the next 6 months to a year.
It does prevent you from ever owning a firearm unless you go back in front of that judge.
So Rhonda was just saying a 6-month commitment does prevent you from ever owning a firearm, legally, I guess. And it does go on your permanent record. whereas the 90-day settlement goes away. That can have impact on things like going into the military and holding specific jobs. So it's a pretty serious thing if you're going to place someone under a commitment. The goal of every commitment is to keep a person in the least restrictive environment. But sometimes that's inpatient, sometimes it's at home. So what happens if the patient doesn't follow the court-ordered restrictions? And I'm going to start with the settlement agreement. The settlement agreement, like I said, is not as strict as the commitment. So if a social worker is getting word from families or of their own knowledge is finding out that a person is not following the rules set up by the settlement agreement, they have to go before a judge and present evidence which says this person's not doing their thing. And at that point, the judge can order confinement in a more restrictive environment. An example would be, if we've got a adolescent on a 6-month commitment and all of a sudden they're on the run and they're not keeping their appointments and they're not taking their medicines, then the social worker in charge goes before the judge, tells them what's going on, then the judge orders that they're placed in more restrictive. They send out an order to the police department and then the police department can pick them up. And this is not a fast process. I can tell you we get calls from social workers saying, well, I went to court this week and got a return from conditional for, Joe, and he's on the run right now and doing drugs, but the police know about it, so he might come in by you when they catch him. And, we may see the patient the next day, we may not see him for 10 days. It just depends on when the police catch up with them. And I don't think it's probably the top of their priority list, so that's the way it goes. But you can't bring them back into the hospital without that court order from the judge saying that they're returning them conditionally. So what about if a person's on a commitment and they don't do these things? That's a whole different ballgame. They can be brought back into the hospital immediately by police or by their social worker can have them brought back in. That does not need to go back before a judge. It does not need to be a court order to the police. So usually what we do have is a social worker will give us a statement basically saying we're going to return them for commitment, but it skips all those going before the court steps. That's just an immediate right back into a more secure setting. It can be a place like us, it can be Winnebago. That's usually spelled out on their commitment. If this person needs detention, they will be detained at, and a lot of times it'll say Bellin Psychiatric Center or like facility. But we do have some that say Winnebago Mental Health, which is kind of, I guess, a little bit more restrictive than what we have. They can hold them a little bit longer than we can. So who are the people involved in this process? There's quite a few. We're going to start out with Corporation Counsel. Corporation Counsel is basically the lawyer for the county, and they're the ones who prosecute the case. They're the ones who look to find the probable cause, and they're the ones that present the case to the judge. They're the ones that get with the help of my case managers, they're the ones who get the witnesses together to testify at the hearing to make sure that they can find the probable cause. The public defender is the other lawyer there. Every person who goes before a mental health court has a public defender. You can choose to have your own lawyer. That's up to you, then you pay, but the county has made the decision, at least Brown County, and actually most counties that I know of, that nobody goes to mental health court without a defender. A director's hold. Now this is different. It's similar but different than an emergency detention. The director's hold is when someone's in a hospital already and they decide they want to leave, and their treating psychiatrist says, I think they meet criteria for an emergency detention. So it's still the same criteria. They have a mental illness, they're a suitable candidate for treatment, and they're a danger to themselves or other. The paperwork is very similar to an emergency detention, only it's filled out by the staff at the facility. The police do not have to be involved. I'm going to tell you from our facility what this means. It means you fill out the paperwork, you make sure you get a copy to your caseworker, or the case managers here, and then the patient here has to have their rights read, because we have rights for patients who are voluntarily here, and then we have involuntary rights. After that point, the case managers here file the paperwork with the county, and then it's handled just like an EM1. Then they can go for a settlement or a probable cause to a commitment hearing. The only difference in this is the way it's handled up front, and that is that the treating psychiatrist is the one who can initiate this. If a patient walks in our lobby and says, I'm going to kill myself, but you can't stop me, I'm walking out, that is an emergency detention. All we can do then is call the police, because they're not in a treatment facility. They're in our doors, they're not admitted. They have to be actually admitted before you can do a director's hold. Any questions about that? Crystal?
I have a question. Like when let's say a staff member is talking with the patient, and the patient is giving them basically the evidence for like grounds for a possible director's hold. So, typically let's say it's the nurse, they contact the doctor and discuss the case. Doctor gives orders for a director's hold. Is there a requirement, not only for the doctor to be a witness, but then that staff member, or is there, how does that work in terms of evidence and stuff like that?
Okay, so the question is, if the nurse sees a person who they believe meets that criteria for a director's hold, and they contact the doctor and the doctor says, yes, initiate a director's hold, who is required to be a witness? A witness is a person who saw the dangerous behavior. If the doctor saw the dangerous behavior, they can be the witness. If the doctor didn't see anything and just got a phone call from you and you're the one who witnessed the dangerous behavior, you're the one who's the witness. I think people get scared off by being witnesses, and I can tell you, nobody who goes to be a witness at a mental health hearing is comfortable with it. That's a for generally speaking, a new experience for everyone. My experience with the whole court system there is that the judges and the lawyers understand that. They are very accommodating. They're very used to working with people who are new at this. It's not as scary as I think. I think it's scary because you're getting up in front of a judge, and you are working with putting someone's life in a pretty restrictive spot. But I don't think that's a reason not to be a witness. I think my microphone's going goofy. Does that work?
Yeah.
Try that. Yeah, Chris?
I was just going to say, I don't think my understanding is the doctor does not have to come in to fill out that form, that it says doctor or designee. So a nurse can fill that form out and the doctor can sign it later.
Yes, that's true. A doctor does not need to come in and be physically present for that form to be filled out. But, yeah, like I said, being a witness is scary for everybody, but when you're doing what's in the best interest of the patient, it's still the right thing to do.
And Diane, I've seen school teachers especially be very reluctant to be the witnesses, and that's why we try to always get the crisis counselor, the police officer, even rather than the parent or a teacher, because we know they're more comfortable with it.
And Rhonda's just saying everybody's uncomfortable with it. So a lot of times, if we have a choice as the case management staff, we will attempt to get the crisis worker or the police officer, people who are more comfortable with it. I can just tell you from my experience, police officers are hard to get. So, yeah, Crystal.
This is more of a statement. So this is for student staff, so that there were like any off hours, like when case management is not present and they're not back till the next day, I would encourage them all to contact the intake supervisor so that they can give assistance and guidance, but also let's make sure that leadership know we have a person on an emergency, like a director's role, so we can support them and make sure it goes through the case management.
So everybody get that? What Crystal was saying is that case management staff are the resources when they're here. And if they're not, we encourage you to talk to our intake staff because they certainly have the expertise as well. Okay, wait, I missed one. So this is just my slide to tell you what's the difference between the emergency detentions and the director's hold. And this is it too, as far as what's the same, you know, the physician's still doing the evaluation, it still goes before a court, it can still end up in a settlement agreement, it can still get dropped. We see that a lot here. Patients will come in and want to leave, you know, a day after they got here, there's still a danger, and the doctor will initiate a director's hold, and 2 days later, they haven't even gotten through their 72 hours. They're much better, they've been on their beds for 2 more days, and the doctor's comfortable with dropping the EM1 and letting them go home. Any questions?
So
Yeah.
I have a question regarding this 72-hour hold. So that doesn't include holidays and weekends, but people can still be detained
Yes.
on a holiday or weekend.
Yes.
It's just their time doesn't start counting.
Correct.
And then what if it's an out-of-Brown County situation? Because I'm sure Marin County doesn't have, like, how does that handle count?
So you're at, there's 2 questions here. First of all, so even though the 72 hours doesn't count weekends and holidays, the patient remains detained? Yes, they do. And that's, I have to tell you, that's really confusing to a lot of patients because the police will go, oh, you'll be there 3 days. Well, not necessarily. You know, if you got detained on Friday night, you're already going to be there like 5 days. So we try to be real upfront with patients when they come in and let them know that. We've also had police officers tell patients, oh, don't worry, you'll be there a day and they'll drop it and you'll go home. Well, that's not accurate. I think that makes it an easy job for the police, but that's not accurate. Your other question was, what about other counties? Other counties work exactly the same. We get patients in here from all over. We have, you know, Oconto, Marinette, Outagamie, Shawano. The same 72 hours applies, everything works the same, the only difference being where they have their hearings. And we do a couple different things here. Several counties around here work with Brown County so that, like Oconto County, for example, if they come in here under a 72-hour hold for Oconto County and they need to have their initial hearing or their settlement hearing, we hear that right in Brown County. Brown County has an agreement with Oconto County that they will do their initial hearing. So we have other counties, Shawano's a big one, that they do they have their patients come here and they do their initial hearing over our television. So we do telecourt with them. And then there's a variety of different ways they do it. Sometimes they'll have a public defender come here and be with the patient while they're on TV. Sometimes they'll have the person meet with the public defender over the television and we just stay outside the room and give them a little time. Or sometimes they have the public defender just calls and talks to them on the phone. It just really depends on the county. There are some counties that don't have telecourt and we don't have a Brown County agreement with, and they actually send the police to come and get their patient, take them to, you know, like Wapaka is a big one, take them to Wapaka, have their hearing, and then return them back here after the hearing.
So is the patient always present at the hearing?
The question is the patient always present at the hearing? 99% of the time, yes. You know, there have been some rare exceptions that I can think of. We've had an odd county here and there that will actually do it over the phone. So they're not actually at the hearing, but they're talking with their lawyer over the phone. That's rare. They're usually there in person or via the television.
And there's always a case manager, parents, or other people with them, the patient. Patients never.
With the kids, not always. Yeah?
If a minor is put on a commitment and it stays on their permanent record, does this stay on the permanent record until they are over the age of 18? Or is it waivers?
The question is, if they're put under a commitment as a minor, does it stay on the record after they're 18? I don't know the answer to that for sure, but I suspect it may. Any other questions, Marty?
I was just gonna say with the different counties, sometimes a person from a different county will do a dangerous act in our county. And so the EM1 is actually Brown County because that's where the event occurred. The initial hearing would be in Brown County, but then it would be transferred over to their own county. So that happens. But I think the ERs see that more than we would ever see it.
I'm just going to restate that so people hearing the tape can hear that, but basically what Marnie said is if a patient from another county comes to Brown County and does a dangerous act, we'll have the initial hearing here, and then they'll change the venue back to their home county. So any follow-up will be done with the home county. Yeah.
Explain the timing, and you said on the EM1, sometimes the police officer will put in the time. What happens if they don't? And then we're on the phone with the county. Are we ever asked to put in that time?
That's a really good question. The question is, if the police don't put a time on the EM1 form, who does? And I know that in Brown County, and I can only speak for this county on that issue, what they're wanting is for the crisis center to put that time in, so that when we call the crisis center and the crisis center comes and says, oh, yep, they meet criteria for an EM1, they would like the crisis center to note that time in there. There are some police departments that are okay with that and some police departments that are not okay with that. I would say as a staff person, we let the judge and the lawyers fight that one out. Whoever wants to put the time on, that's fine with me. It's not our form, it's their form. Yeah, Shelley?
Is the form in a database so that crisis can see the same form that the police are filling out?
Your question is the form in a database?
Yeah, like how we have like medical records, they're in one section. Do they have something between Brown County and the crisis center where the EM1 form is in there that the crisis worker can sign off on that?
No, the form is a federal form, and it actually is produced by the police. The crisis center may have copies of it or it may have access to it, but the form is supposed to be initiated by a police officer. So, and I know for the police officers we work with here, most of them, it's on their computer database and they fill it out and print it out, so.
So if we have the EM1 here and a crisis center and the police didn't sign off on the EM1, but the crisis county worker has to, how is that done? Do we fax that form to them?
No, we don't mess with the form. If a patient is here and they get put under an EM1, like if the police come to our lobby, up to them to fill out the form. We don't do it. Getting crisis center okay is up to them. That's not our job. And that's kind of what I was saying about the EM1 forms. Our job is to say, do you have an EM1 form? That's it. Who fills it out and what they fill out, that's up to the police and the crisis center.
I thought we were told that the nurses were supposed to make sure that the form was filled out properly, that there was witnesses listed, that the county was on there, that there was a time on there.
That's the way we used to do it until the law got complicated.
Okay.
And the direction now is
That's what I'm wondering.
make sure the form is filled out. If it's not filled out, I mean, if they can't give you a blank form, but you can ask the officer, if there are no witnesses, you can say, do you have witnesses you want to put on here? I would not say you didn't put a time on, or you should time it now, or have them come back and put a time on. That's part of their legal job, is to put that stuff in there. And if they don't have the appropriate date and time on, that's something for the lawyers to fight out, not something for us to get in the middle of it. when it was really clear that the police made the decision, and it used to be that the emergency detention started when they walked in the door here. That's not the case anymore.
Okay.
So for us to ask them to put the time on when they walk in the door is messing with the legal process. And because there is so much up in the air about who should put what time on there, I don't think that we should make any decisions about that. I think that should be done by the police and the crisis center. That's what their job is.
So a completed form doesn't necessarily have a time and date on it?
It should have a time and date on it. What the time and date is up to the police and the crisis center.
I have a question, Diane. So
Yep.
that's the issue, because then when we come in the morning and we have a form that is not filled out properly, does that mean that patient's here illegally? So it does fall on
Now,
us.
if you have a form, they're not here illegally. If it doesn't have the rate, date, and time on, then you fax it over to Corporation Counsel and say, here's the form we got, what do you want us to do with it?
Yeah.
And they make that decision. That's what I'm saying.
I guess while we're talking about the form, I have a question about the form too. So the police officer that needs to sign the form, so that be, and the other thing that is sometimes a direction given that I'm not sure if has changed either, like in the past, if they were in the psychiatric center, we wanted it to say detained at Bellin Psychiatric Center, not just Bellin Hospital.
Yep.
But, so, is that anything we need to be concerned with anymore or not?
The question is, should it say Bellin Psychiatric Center, not Bellin Hospital, and does the police need to sign it? The policeman should sign it. There's a place on there for the policeman who's detaining to sign his name. That just helps us to do the follow-up and helps the Corporation Counsel to do the follow-up. As far as, what was the other question?
If it says Bellin Health or Bellin
Bellin
Health,
Bellin Psychiatric Center or.
and they do come in like that.
They do come in like that. The problem is with the new law, they are supposed to put where they are detained first. And oftentimes that is at the medical hospital and not here. Now, if they bring them here and hand it to us, my assumption is they want them detained here. I don't think we mess with the form. Barney or Megan, you got any other opinions on that one?
Didn't they have a second spot on there where they're
Does it have a
detained
second
and then they
for?
come to the
So
next
if they want to
spot?
say detained further at Bellin Psychiatric Center, that's fine.
It almost seems like we should have at least to check that they're detained at the Bellin Psychiatric Center. Because from Bellin Health, they could go anywhere, I would think, but I don't know the.
Sometimes they've been writing it twice, like detained at Bellin Hospital there, and right underneath it, detained at Bellin
Yes.
Psych at the same time.
Yeah. And I'm fine with that if they put both things
Yeah.
in there. Yeah.
And I guess that's kind of part of my other question. So how is it affected, is it affected at all? So we say it's 72 hours, but suppose like the person needs medical treatment in the hospital for 24 hours or 48 hours. How does that affect, does it affect the timing of the EM1?
It does. Karen's asking, what if they're detained at the medical hospital and it says the actual time of detention at the medical hospital? Yes, it does affect the EM1s. We've had them walk in our door and be dropped because the detention started at the medical hospital. What is supposed to happen, if it were a perfect world, is that the Corporation Counsel or whoever gets notification of the EM1 and the public defender should be talking about this. Public defender should be going to the medical hospital, seeing if they can meet with their client. Okay, if your client overdosed and they're in a coma, probably not going to meet with you. But at that point, the public defender can go before the court and say, my client is unable to help in his own defense. Could we postpone this hearing for a week or 3 days or whatever? The public defenders are choosing at this point in Brown County, and I'm only speaking for them, not to do that. And the reason being because exactly what Karen said. If they don't do that, then the hearing doesn't get extended and the whole matter gets dropped. And in a legal sense, that's kind of what the public defender wants, is that their patient not be held under a commitment.
Well, they will call here and ask the patient, are they okay with putting it off till the next hearing date in Brown? They will ask them.
So Rhonda's saying they will do it if they're here, but yeah.
What
Seen
is the
it.
process, how does the public defender know somebody's in a coma in in the ICU to know that they have to make that determination? Does the ICU call him?
Yeah, we contact them.
Okay.
Okay, so Marnie's question was, how does the public defender know? And the answer is that the hospital social workers at the main hospital do call the public defender.
Is there a way we could avoid, because we do see sometimes where the time will start in the hospital and the patient's in a coma, then the EM1 gets dropped before the time of discharge. If the patient who gets discharged doesn't want to voluntarily go get psychiatric help, therefore this patient who just tried killing himself never gets any treatment. Is there a way that we could avoid that?
So the question is there a way to avoid those EM1s from falling through the cracks when they've been not medically cleared and public defenders there? The only way to do that is to get your corporation counsel to take it to court, whether the patient's there or not.
So we would challenge.
So I would challenge the corporation counsel, and then, you know, if the corporation counsel says to the public defender, I'm going to take this case to court whether your client's ready or not, then it's in the client's best interest for the public defender to go there and get the hearing postponed. But when nobody pushes it and by not responding, they can get the case dropped, it's easier for them to do that. Yes?
So, here at the psych center, like when they're detained here, you guys have black nursing units that they like aren't able to leave. But if they are at the hospital, because they're medically unstable, like our nursing units there are not. Like, what do you do if they're like, well, I'm not staying here, I'm leaving? Like we can't physically hold them down and tie them down.
So the question is, what if they're at the hospital and they're not medically cleared, but they're physically able to get up and walk out? And the answer is you call the police if they walk out. We don't detain them here either. You know, we're responsible for taking people to court. And we've had this happen. We'll be sitting waiting for the court hearing to happen and the patient takes off. We're not going to chase them down. We're going to call the police and say, you know, your person was being detained, but they were, you know, able to get away from me and run away. We're not going to challenge that. We just call the police, and that would be the same at the medical hospital.
So you're saying that if somebody is detained here and they need to go to hearing, so then Bellin provides staffing to kind of.
Yes, that's one of the oddities about Brown County. When we have a patient that has to physically go to court, and we do telecourt here with Brown County, but when a patient has to physically go to court, we actually have a group called Lock and Load, and they are police contracted, I guess, drivers that come, handcuff the patients, take them out to court. But we have staff that meet them out at court, sit with them in the waiting room, attend the hearing with them, and then meet them back here after the hearing. So yeah, so if you want to know about court, I've got Megan, Marnie, and Rhonda, and Lisa here who go to court all the time. So if you have questions about it, they'd be glad to answer them. Any other questions? Lisa?
So I know this has to do more with what happens after they leave our facility, but what if you have a minor who agrees to the settlement, but the guardian wants to fight it?
The mental health court, Lisa's asking, what if the minor is agreeable to the court action, but the parent is not, and the guardian is not? It doesn't matter. The court hearing is with the minor. Doesn't matter. Brown County will not take kids 12 and under to court, or 14 and under. They don't like to do that. But according to the mental health statutes, at 14, you're able to consent to these kind of decrees. So whether your guardian wants to or not, the court can still put you under the stipulation agreement or the commitment at 14.
So then if at 15, the patient agrees, the parents don't bring them to their appointments and follow through with the parental piece of it, then CPS gets involved?
No. Okay, so the question is, you've got a 15-year-old who's not attending their appointments because their parent won't give them a ride. What happens is then it's up to the social worker to make a decision. The social worker can choose to bring them back into the hospital as a return from conditional, and then pursue the commitment, because when you're still in that 90 days, you can go for the full commitment. And then the county has a little more teeth behind it. Or they can say, you know what, this kid's doing the best they can. They're trying their very best to follow the settlement agreement. Requiring them to get to appointments which mom won't take them to isn't realistic, so we're not gonna pursue it. That's kind of up to the social worker.
No, like neglect involved in there or nothing, like CPS?
They can try to go for medical neglect on that. I think they'd have a hard time with that. That wouldn't really rise up to, and it's not that, you know, technically it probably does meet the criteria for neglect. It's just that when you look at the scope of abuse and neglect going on, that's gonna be low on the totem pole as one they wanna pursue. Rhonda?
Is it okay to just share? So we hear a lot of complaints from parents about how they don't get to have a say if their child's going to be put on a 90-day or a 6-month. And we gently have to explain to them what Diane said, the order is on them. Your role as a parent is to do your best to get them to those appointments. If you're gonna have troubles with that, let the county worker know so they can help you with gas money or whatever you need, transport, to get them to that appointment. But they're usually fine with it as long as you just do a good job explaining. And it's a resource and a support to them too, because it's a county order. So it's not the parent saying you need to go to treatment. It's the county saying you need help, we want you to be well. And so we really phrase it as a support to that child and that family.
Just going to recap, Rhonda's just saying that we encourage parents if they disagree with court to look at it as a resource, because they've got a social worker assigned who can, you know, help them with transport to appointments and help make sure that they're getting what they need for their child. Any other? Yeah?
I'm on the hospital side, and if I have a patient that's gonna be close to the 72 hours, it sounds like there's certain days that court is, or are there more reasons I should be touching base with court counsel other than the 72 hours?
So the question is, if I've got them at the hospital and they're getting close to their 72 hours, is it more important in some cases rather than others, depending on where the 72 hours falls? I can tell you for Brown County, it's very important. We only have court twice a week in Brown County. It's Tuesday mornings and Thursday afternoons. So if a patient is on a 72 hours, it's not going to run out till Friday or Monday, and they're getting medically cleared Thursday morning or Thursday afternoon. Yeah, that's pretty important, because if they don't get to us till noon on Thursday, they've already missed court. We have to have the court set by 11 o'clock on Thursday morning. So even though their EM1 might not run out till Monday, that they've still missed court because the next available court is Tuesday morning. Now, can we do a special hearing? We can. It takes almost moving a mountain to get a special hearing in Brown County. So they're pretty much want us to do the courts on Tuesdays and Thursdays if we can. And we do our very best to make sure we can. Karen?
Could you talk a little bit about, sometimes I hear physicians make the decision to, well, let's let this EM1 run out. And what happens, you know, what are some reasons for that decision, and then what does that mean to us as staff?
Okay, so the question is, what does it mean when the doctor just says, we're gonna let the 72 hours run out? It means that we're gonna keep the patient in the hospital for the 72 hours, and then at the 72-hour mark, we're gonna drop the hearing. We're not gonna pursue a hearing, and what that does is gives the doctor 3 days to treat the patient, whether they wanna be treated or not. Now, does that mean they have to take meds or anything? No, they're not ordered to do anything like that yet. So what it does mean, though, is we're gonna have 3 solid days to look at their behavior, or 5 days, depending on where that 72 hours falls over the weekends. But it gives us time to work with the patient, because sometimes all they need is time. You know, they need time to be able to do some groups or to do some individual therapy, or to maybe consider, you know, starting on a medication that a doctor feels is appropriate. So by not pursuing court but not dropping the EM1, we get that 72 legal hours to work with that patient.
So then, at the end of that, the patient will have to sign in voluntarily?
Right. At the end of the 72 hours, then the patient has the choice. They can sign in voluntarily or they can leave. But I know that we've had cases where sometimes they just need that 72 hours to kind of get a grip on how things are really going, and that's all they need. So.
The other question I have is about third-party petitions, because I know we'll have, like, families will come up and they can take care, they'll be concerned about their loved one, their family member, maybe doesn't meet the dangerousness criteria, yet they're, psychotic or something along those lines, and they are asking staff a lot of questions about third-party petitions. Can you tell us a little bit about what's involved with that?
So the question is, what's a third-party petition? A third-party petition is where a patient is not under an emergency detention, not being evaluated through a psych hospital like this, but a family can say, I think, my loved one meets all these criterias under the Chapter 51 statutes, and I'm going to try and find 3 independent doctors who will be willing to testify or to sign off. No, Marty?
It's 3 people. Well, it can be 3 family members or 3 people that have observed the dangerousness, and it's more of a chronic rather than an acute situation. In an acute situation, you call the police or whatever. But when you see this person deteriorating, but they don't quite meet criteria, they can have 3 family members or whoever write out a report of the dangerousness, and they present it to the corporation counsel attorney, and then she'll review all that, and she'll see if she has a case, if she thinks she could argue that in court, and if she thinks she can, then she'll go before the judge and get an order to pick that person up. Then they would come to us, and again, just like the director's hold and the EM1, the same process occurs. It starts to be the same process. There's just 3 ways to get in onto a 72-hour hold. Either EM1, director's hold, or a 3-party petition, and the process would start there.
Okay, I'm just going to say it again for the camera, but what Marnie explained is that a 3-party petition means that we get 3 family members to do, or 3 family members or friends or whoever, people who have knowledge of this person to fill out reports saying that they are a danger to themselves or other, that those 3 petitions get presented to the Corporation Counsel for Brown County, and then the Corporation Counsel can take that or have that person detained for the purpose of a 3-party petition, and from there on it would go just like in any other emergency detention. They'd have the 72 hours to evaluate.
The best advice to give them would be to go to the corporation counsel, give them the corporation counsel's number, and then they'll direct them on how to do that and what they need in that, so that if you ever get a family member.
And then Marty, do the police pick them up at home and bring them here? Okay.
Okay, so what Marnie's direction on that was to refer them to our Corporation Counsel, and in Brown County that's Rebecca Lindner with the Corporation Counsel office, but every county has a Corporation Counsel, and then if the Corporation Counsel accepts those 3-party petition, then they would have the police pick up the person for a detention. Thanks, Marnie. Any other questions? All right. Thank you so much for your attention, and thanks for coming.